Hey, good morning, good afternoon, good evening, good night, wherever you are, whoever you are, whatever you're doing, however you're doing it with, however good it feels, however many times you plan on doing it. Is me, Legal Vices, and I'm just glad you're doing it here. Welcome, welcome, welcome. Here we are, one day out from the Taylor Schabusiness trial. It's going to be starting about 24 hours from now. This is our last chance to brush up on things that have been going on so that we're ready to rock and roll when the trial starts. That's what we're going to be doing here today. We're going to be watching a little bit of the hearing, the competency hearing. We watched some of it the other day. We're going to watch the last little part of it tonight, which tonight's time for me. It's morning time for those of you in the States, and it's kind of somewhere in the middle for everybody else. We're going to be watching that. We're going to cover some of the motions. Two of the motions we want to get through tonight are the motion to suppress evidence and the motion to dismiss one of the charges, the SA of the victim. So that's the plan. And we've got here on Legal Vices, we have a Lincoln Kane raid. Everybody needs to go over to Lincoln Kane's channel as well. It's a Shani, S-H-A-N-I. There's a gorgeous woman, Lincoln Kane's partner, and a kangaroo. That's how you know. That's how you know you're on the right trial. That's Lincoln Kane. Go to Shani. People, they're mods. If you can throw up Lincoln Kane's link in the chat, that would be awesome. So we can show them a little bit of love for giving us a Lincoln Kane raid. All right. So where to start? Well, let's do all the housekeeping things here first. We got 173. Let's try that again without the lisp. We have 173 concurrent viewers here, and we already have 114 likes. That's good. The other 70 of you need to get down there and smash that like button. 60 of you. Yeah, the other 60 of you need to get down there and do that. Hit the like button. Hit the subscribe button thing if you haven't already done so. We're picking up quite a few subscribers from Melly and this trial. We're sitting at 57,185. 60,000 K is possible by the end of this week if we continue going as we have been the last day or two. So, hey, let's see if we can get to 60,000 subscribers. We only need 3,000 more by the end of the week. I think we can do it because this is going to be a big trial. This is going to be a hit. I've been pushing this. I've been pushing it, just so we can get all the viewers we possibly can here because we're going to have a weird to say we're going to have a good time with this horrific trial, but we're going to have fun over here. As much fun as you can possibly have. It's, that's what we do. This is a commentary channel. We offer commentary on the trials. It's if you want to just sit there and, in silence and watch the trial, Law and Crime, Court TV, they're going to be your places to go. Here, we offer a little bit of levity in the seriousness. And speaking of awesome people, Bella Stella, starting us off with the first super chat of the night. Or is it the second super chat of the day? We're going to talk about that in just a second, too, because Bella Stella says, let's get down to Schabusiness with a $10 super chat, making her already the vice racks of the day. But also, earlier on in the day, Bella Stella, she dropped a $5 super thanks in the chat. Bella Stella, I hope you enjoyed your 30 seconds as the vice racks of the day. Lincoln Kane has just crushed you. Sorry. But yeah, we've got this trial coming up, and it's gonna be a big thing. We try to offer a little bit of levity, we some commentary. We've got a bunch of feelers out for people that have said they'll come on if and when they get the time. We'll see how this goes. Just kind of scrolling through Nicholas Starov, Steve Gosney, Danny on direct. Who else do we have here? Oh, my messages are weird. My Twitter messages seem to have been truncated. Rob from Law and Lumber, and I can't think of the others off the top of my head, but we do have a lot of invites out there. Legal Mindset Andrew. It's going to be fun to see when people can drop by. It'll just kind of be random. They've all going to have their links and everything. So, all right. Make sure you hit the like and subscribe and take our like and subscribe poll today. It's our first official poll of the Legal Vices Taylor Schabusiness trial. Stab the like button, slash the subscribe button, vote on how you think this trial will go. How will this trial go? Your choices are, it'll be a cut above the rest. Awesome. Let's take a stab at it. It'll be dull as a kitchen knife. And we need at least one crock pot recipe. Because as you know, there was a leg and a foot found in a crock pot box in her roommate's van. So thanks for that, Shabiz. I'm sure the roommate appreciated that. Meme Copy Math, did she have a nibble? As I've been saying since this thing happened over a year ago, if she did take a nibble, if she maybe licked a blade or two, if any of that went on, that would be the least horrific thing she did that entire evening. So we'll have to see if there's any testimony to that, but you know, it's a thing in Wisconsin apparently. So we'll just have to see how that goes. But as I just alluded to a minute ago, Shani, aka Lincoln Kane, dropped a big one on us, a 200 Aussie dollar super chat, who is clearly clearing far and away the vice racks of the day. Deep appreciation to you, Lincoln. Thank you so much for that. I don't even have a shot of whiskey to do here. We'll have to make up for it tomorrow. Promise we'll make up for that shot tomorrow. My liver's taking a break after hosting a house party with a bunch of Russians last night. We're in detox mode. So thank you so much for that. And Christine Fortunato, thank you so much for your super chat. Is anybody live streaming? Is anybody live streaming? Do you law bad crim? Do you law and bad crime? I'm not. If I ask questions, is anybody going to be live streaming the trial, like Law and Crime? It's not going to be on Law and Crime. Law and Crime will be live streaming it. We'll be using their stream. If not, there's several other places where we can do this. So yes, that we're expected to start about 23, 24 hours from right now. So stand by. We will have all of the updates. We will be covering this gavel to gavel, and this is our last chance to figure out exactly what has been going on. Let's see if there's anything else we need to get out of the way before we jump into this. Looks like we are good to go. And again, one more 280 people here already. This is going to be awesome. We're going to have a good trial, good guests. It's going to be a good stream. And we are ready to go as soon as we get this last super chat that's waiting to scroll up here. All right. Just give her all the way, all the live long day. All right, we're going to be doing it. Thank you so much. Dickered with Dave 2. All right, so what we're going to do first, we're going to do the end of the competency hearing. We watched we watched the court-appointed psychologist's opinion on whether or not Taylor Schabusiness is fit to stand trial. He said she was. And the court volume was not the greatest. What do you mean my title is incorrect? It's Wisconsin. Yes, it's Wisconsin. What does the title say? Florida. Why does it say Florida v. Taylor Schabusiness? That hurts my credibility. Wait just a minute. We need to correct this wrong right now. What the heck? How did we get Florida involved in this? That's weird. We've been stuck in Florida with the YNW Melly trial. I think my brain was still there when I was doing this because I actually arranged this live stream during the YNW Melly trial. While I was watching it, I was doing this there. Holy crap. That's embarrassing. There. All fixed. Thank you so much for that heads up. Yikes. All right. Got nothing to say other than don't know where my brain was when I did that. But we're already, look at this. We are already limited on monetization. Somehow, when we read that criminal complaint with all of the horrific details, that we got into some really, really gory details. When we did that, our monetization was strangely not affected. But now we're already limited. We're already limited on our ad suitability. That's the old Taylor Schabusiness live streams I'm used to. Let me request a review right now. So maybe we'll be green by the time we get back. But yeah, this has literally happened every time. We get limited in our ads, and sometimes it just goes red, which means zero monetization for the stream, because this is one hell of a situation. So let's see how that goes. I'll keep you posted on the monetization effect as we go through. We do need to get into this, so we will give a super special thanks again to Dickered with Dave 2 for the super chat. And as the super chats come in at natural pauses in the story and whatnot, we'll cover them. We'll make sure that every single super chat gets read and addressed, and we'll see what else we have going on in the chat today as we go along. Right. Let's present the video. This is from Court TV, and unusual. It's not usual that Court TV has closed captions, but they do on this. So congratulations to them for giving us some closed captions finally on a video. Alrighty, are we ready to rock? No, see, Medita Finn, we're not going to change the title to mask her name. This is it. People are searching for Taylor Schabusiness. So it doesn't matter. We're going to do this. We're not beholden to YouTube. We kind of are, but you know, they can do whatever they want with the ad revenue. I mean, the ad revenue is like $5. You get like $5 a month for it. It's almost nothing, but it's still just annoying that you can do some of the things you can do on YouTube, but you cannot talk about the facts of a trial if it's particularly heinous. So that's just a thing. It's more of a challenge at this point. So we'll just have to see how it goes through. This is the judge. I like the judge in this case. He's been fair. And from earlier on this year, he has been set on getting this trial to go on July 24th. He hasn't let anything step in. He hasn't let anything change that opinion. And he's going for it. And we are ready to go. So let's watch the end. What we've seen here was a week before this trial happened, a week before this hearing happened, the defense, they put their defense expert on. We streamed that. It was really hard to hear this woman, but she gave off very much the Johnny Depp trial, Dr. Spiegel vibes. She was an odd one. And of course, the defense expert that the defense paid for to comment on whether or not the defendant is competent to stand trial, she came back and said, why, yes, of course, the person that you paid me to figure out if she is competent to stand trial is actually not competent to stand trial. So that was her opinion. She wasn't competent to stand trial. And then on Friday, we had the court-appointed expert give his testimony. It was a little easier to hear, but we have both of those up. If you go to the Taylor Schabusiness playlist on my stream, you'll be able to watch both of those. And these are the comments that the court made after the court-appointed expert gave his testimony. All right, let's do this thing.
Okay, then I will turn to the state for an argument. Mr. Lizet.
Thank you, Your Honor. As the court is aware, it is the state's burden at this juncture to demonstrate by the greater weight of credible evidence. So it is a relatively low burden, but it is the state's burden to demonstrate that Ms. Schabusiness is competent to proceed in this matter. I think when the court considers the totality of all the information before it, that it's quite clear that Ms. Schabusiness is in fact competent to proceed in this case. And this is a judicial decision. It's not a medical decision. It's a decision that the court can make based on a variety of.
That's an important thing to make. Again, two important points here. One, the defense doesn't have to prove that she is not competent to stand trial. The prosecution, once they've said she's not competent to stand trial, the prosecution has the burden of proving that she is competent to stand trial. And it's not a medical decision that the psychologists make. The psychologists from both sides give their opinion, and the judge will make. It's a question of law or a fact. You know, the judge will it'd be a legal determination for the judge to make. He will look and weigh the evidence given by all of the people. She's been evaluated 5 times by 4 separate psychologists. So 5 times by 4 different doctors. He's going to weigh all of this. He's going to weigh all of this evidence, and he's going to decide the issue of whether or not she's competent to stand trial. It's not a medical decision.
Of different factors. We've now had 5 different competency evaluations in this case. Dr. Litton's evaluation is frankly the only evaluation that suggests that she's not competent. I think
again, another that is a point as well. As I said, 5 evaluations by 4 different evaluators, and the defense is the only one that said she's not competent to stand trial. The other 3 evaluators all said she was competent to stand trial, and one of them did it twice.
I think there are a number of flaws with Dr. Litton's evaluation, and I think that Dr. Seipel's report and his testimony here today call into question a number of her findings and certainly the methodology that was used today. And I do just want to take a moment that when I asked the question about Mr. Freilich being present, I certainly was not intending to suggest that Mr. Freilich did anything inappropriate at all. That was not the purpose of my question. I think to the extent that Dr. Litton had someone else in the room, that's a decision she made that may not be consistent with best practice, but I don't want to suggest that Mr. Freilich made any attempt to try to influence competency.
We'll talk about this in a minute.
I do
Hello.
think that
Good question.
what clearly makes the most sense is Dr. Seipel's ultimate conclusion in this case, which is that to the extent that there are any potential symptoms of psychosis in this case, that those symptoms had generally been driven by two things: intentional use of illicit substances, particularly methamphetamine, and then volitional conduct, frankly, on the part of Ms. Schabusines. And of course, as the court is to consider, it isn't just does she have a mental illness.
Again, he's saying if there are any mental problems on her thing, we think the evidence has shown that, one, it's because she's doing massive amounts of drugs, and two, she's intentionally acting this way.
Does she potentially have some sort of symptoms that may in some way make it more difficult or more challenging for her to participate? The issue is, do those symptoms, if they exist, do they substantially impact her ability to understand what's going on and to assist in her defense? And I think quite clearly neither of those things are present.
Okay, this is a good time to address the question that I said I would be addressing a little bit later. He sort of provided us with the natural time to do it. Hello, it says a mentally fit is kind of a BS out. I mean, you either did it or didn't. WTF doesn't matter if you were crazy or not. That doesn't change the fact you did it. No, it doesn't change the fact that you did it. But it's whether you can be held criminally liable, criminally responsible for doing this if you're out of your mind. This is a two-step process. What they've been arguing is she competent to stand trial? First, they're establishing that she can go to trial. And what that means is what he just said, that does she understand the nature of the proceedings? Does she understand what's at stake here and what's going on? Does she understand she's on trial for murder? And two, is she able to assist in her own defense? So if you're so gone that you don't even know why you're on trial, and you can't do anything to help your lawyer, build your case, then it's the legal viewpoint that it's not fair to you to put you on trial and to threaten you with life imprisonment if you don't even understand what's going on. And normally what happens is if you're found not competent to stand trial, I don't exactly know how it works in Wisconsin, but if you're found mentally incompetent to stand trial, you're not able to stand trial, they put you in psychiatric care until you are able to stand trial. And then they put you on trial. So it's not like, okay, you're not competent to stand trial, there's the exit door. They treat you, they put you in a psychiatric facility. And again, I don't know exactly how it works in Wisconsin, but they put you under psychiatric care until you are fit to stand trial. Then once you understand what's going on, they put you on trial. And the next step is, as they've done here in this case, they've said that she's not guilty by reason of diminished mental capacity, which is basically not guilty by reason of insanity. They might refer that here as an NGI. They've done it before. Not guilty by reason of insanity, which means that at the time you did it, what you didn't appreciate that it was wrong. What you did it, but you didn't appreciate it was wrong. You were so crazy you didn't even know it was wrong what you were doing. And that's where we're, so that's why it matters if you're crazy. And now crazy and not competent to stand trial are different things. So those are the big questions. And this is what they're answering now. Does she understand the nature of the proceedings against her, and can she assist with her own defense? The prosecution is clearly saying yes. Anything that would prove otherwise is herself doing massive amounts of drugs and her just acting this way. And if which we clearly know that they get through this because trial starts tomorrow. But then they're going to be arguing whether she knew what she did was wrong at the moment she did it. So that's the answer to that question. That was a very, very good question. Thank you so much, Hello, for bringing that up.
Frankly, I'm not sure that even the motion from counsel suggests that there has been a significant impact in his ability to work with Ms. Schabusines on this case as a result of any of those perceived symptoms. And in the interviews that she's had with all of the clinicians, she appears to generally understand the concepts, the legal concepts. She knows who her attorneys are, what the role is. She knows what the state's role is. She knows what the court's role is. She understands what she's facing, why she's here. And she is able to pretty substantially describe the facts that put her in this position. And the court is able to consider all of the facts and circumstances that are available and its own observations of the defendant at counsel table, of her ability to sit through lengthy, complex motion hearings without disruption, and apparently to assist her attorney throughout that process, and Mr. Freilich's ability to communicate with her quite well. It does appear that she and Mr. Freilich have developed a quality working relationship.
Yes, she's the one who attacked
and
her.
that she's able to assist him in this process. I think when the court evaluates it is met by the weight of credible evidence that Ms. Schabusines is competent to proceed in this action.
So that's the state's deal. She knows everything about what's going on, and she's actually helped her lawyer. Now he's saying, nope.
The law, Wisconsin law 971.14 subsection 3 of the Wisconsin statutes indicates that no person who lacks substantial mental capacity or understanding of the procedures to assist in her own defense may be tried, convicted, or sentenced for the commission of an offense so long as the incapacity endures. We have a young lady here, Taylor Denise Schabusines, who does have mental health problems. She's been at Bellin Psychiatric Center for mental health treatment. They said that she had bipolar disorder with psychotic features. She's been to the Nicolay Psychiatric Center for a commitment, 6-month commitment order. She was there for about a month, but she was under a court order for commitment that was filed April 1st of 2021, and that she was deemed to be mentally ill. She was deemed by the court to be adjudicated as a mental defective or committed to a mental institution. She was at the mental health institution, and that she was under a court order to take psychotropic medications. So she has a history here of lots of problems. The Brown County jail records bore out that she's had problems with following directions, standing for head count, drawing on the walls, doing all kinds of bizarre and odd behaviors. And what we have
Is
here
she faking it?
are
That's what all the other
two
guys were saying.
diabolically opposed conclusions or opinions from the psychologist here. Dr. Seipel feels that Taylor.
See, he diabolically opposed. We talked about this last time. He says diabolically opposed. He means diametrically opposed, not diabolically opposed. Just pointing that out.
Schabusines is competent, and our doctor, Dr. Lighton, who has a lot of experience, she opines or concludes that she's not competent. So we have a problem here. We're at a crossroads. We've got some issues that have to be sorted out. I beg to differ with Dr. Seipel. I mean, he testified that this is not a complex case. It sure is a complex case. There's lots of records. There's lots of history here of mental health problems, drug addiction issues, all different kinds of problems. I think that both of the doctors have a lot of information, have a lot of training. They've looked at all these reports that have been submitted to the court. But Dr. Tracy Lucetta, who's also a PhD, she sent in a report that was filed on May 6th of 2022 when my predecessor, Attorney Jolly, was on the case. And she indicated that she recommended that my client be transferred to one of the state's psychiatric facilities like the Mendota Mental Health Institute or Winnebago Mental Health Institute for further evaluation under close and extended observation by qualified professionals. If she was sent to a state facility like that for a week or a month or whatever time is needed, a whole team of professionals could assess, fully assess my client's competency to proceed in this case. There are all kinds of issues here that have to be sorted out. It's not a clear-cut case, in our opinion. And I would argue that, you know, a 90-minute interview by Dr. Seipel with Ms. Schabusines, I don't think that is going to be able to be enough time to really fully understand and address the issues in this particular case. You know, Dr. Seipel didn't do the MMPI or the MCMI. Dr. Lighton did not. Dr. Engine apparently did. I also want to comment on the issue with Dr. Lighton. She asked me to sit in, and I know that there were concerns because the chair was thrown at her, and she's an older lady, and so I sat in, and that's what happened there. I didn't get involved. I stayed out of it, but I was just there for, I think my client felt more comfortable with that. So I just want to comment on that. But I believe that my client is not a very good historian. I think she's got memory deficits. We've got all these records that I've poured over and looked at, sent to the court. I think that my client has had or does suffer from bipolar 1 disorder based on my review of the records. And, you know, based on her conduct with regards to throwing a chair at the professional that's trying to evaluate her, attacking her, Mr. Jolly, allegedly previously in court, engaging in other courtroom antics, the staple going into her arm, not taking medications, you know, who knows? Who knows if the drugs, the methamphetamine, the marijuana, the cocaine, all these other drugs, did they cause brain damage? Did they cause a mental defect?
Well, you should have had your expert
That's all
testify
for
to
the
that, my
court to
friend.
decide, but I submit that it likely did, and it's
It
caused
likely
a
did,
lot
but
of
you
different
didn't have
problems
any
for
medical
Ms. Schabusines
testimony to
with
that
being
effect.
able
If you want to
to
argue that maybe
really
the drugs addled her
participate,
brain,
understand
you
what's
should have
going
had
on,
someone
assist in her own defense.
testify to that.
The fact that she apparently did have some hallucinations in the past, I think all that leads to the conclusion and my argument that my client should be deemed not competent at this time, or if the court doesn't feel it can even make a decision on that, send her over to Mendota or Winnebago for a further evaluation. Then we'll know. Then we'll know for sure if she's ready to participate in a trial and assist with defense counsel and be able to understand what's going on. I have some serious reservations on her mental status, especially in light of the civil commitment, especially in light of the order to take medications. She has been deemed mentally ill by a court of law. So nobody can dispute that. I would submit that that's likely continuing, but there's all kinds of different opinions here. So I'd ask that the court go along with my arguments that she be transferred to one of the state's facilities for further and extended observation. Thank you.
Mr. Freilich. Well, I've had an opportunity now to listen to the testimony of both of the evaluators. I've also had an opportunity to review both of their reports. I've had an opportunity to observe and weigh their
Yes. Hello.
issue
There we
business and
go.
how she's
Welcome back, Sport
participated in this
TV.
case. And on several occasions in the past when we've addressed this issue, I've had I've reviewed the history, and I'm not going to review the history of the competency process that's gone through here in this case again, because I've done it several times.
I like this judge a lot.
But I want to highlight a few
Soft-spoken,
things.
but very, very
That is that
strict,
on
very, very
3
firm.
separate occasions, this court has ordered, has tasked the Wisconsin Forensic Unit with assessing Ms. Schabusines' competency. And I know there's been other evaluations that have been conducted as well. But in the first one, Dr. Collins really cautioned the court to maintain vigilance on this issue throughout the case. And I have done that. I have done that. and I've listened to the request for on various occasions to have more competency evaluations conducted. On a few of those occasions, I've denied that request, and then this time I granted it because Dr. Lighton came forward. Really, each of these evaluators has a different opinion. Dr. Lighton's opinion on page 2 of her report is, quote, "My opinion also is that to a reasonable degree of psychological certainty, Mr. Business is not competent to proceed to trial," close quote. Dr. Seipel, as he testified here today, has an opinion directly to the contrary.
And it was directly to the contrary. She's saying she's malingering, she's faking it. Nothing we saw indicated that any of this was going on. We do have just a couple of chats that I starred here that I want to mention. Do we know how many witnesses are going to be? The trial is scheduled for 1 week, so you're looking at opening statements, a couple of days of arguments, and then the jury deliberation. This judge fully expects this thing to wrap up on Friday, so not many is the answer to that question. And Medita Finn says, legal advice is, what is the defendant gaining for finding him or her incompetent is just delaying the trial. What they're gaining is a fair trial. They have to be able to understand what they're on trial for and have to be able to contribute in some way actively in their own defense. And you're delaying it because it wouldn't be fair. So that's what they're gaining. They're gaining a fair trial. And that's the long and short of it. An MLS law so says, KT, I don't think that would be KT asked if there's going to be a bifurcation, like 2 separate trials. I don't think that would be a bifurcation on that. The state has to prove she did it and that she was sane at the time you'd handle it. I think the same thing. I agree with MLS law that they would be doing that at the same time. And up to this point, there hasn't been any indication that I've seen from this defense lawyer that they're going to be arguing she didn't do it, because they're just arguing that she was insane at the time she did it. You can't claim you were insane at the time you did it if you're also arguing you didn't do it. So I think they're just going, I mean, even proving she did it is going to be very, very easy, considering that she told the police exactly how she did it. And she was still covered in his blood when they found her at her home. And she corroborated the police investigation as was going on. They had a phone with her and then a phone back at the crime scene where she was corroborating things back and forth and actually correcting them in a few places. So there's really not much of a problem with arguing she did it. So I don't think they're doing it. It seems like I've seen nothing from the defense to say that they're going to be arguing that she didn't do it. They're just arguing she was insane when it happened. And Jack Matt, this is Schabusiness, Ms. Schabusiness, I guess that's what we're going for, should have flashed the judge. And LC Amara says Schabusiness flashes her breast at Judge Tarantino, I'm more of a feet guy. How about you kick off those jail-issued Crocs? Yikes. But she did apparently, which we gathered, she did flash the judge at one point. That was one of the things that the defense lawyer was arguing, that she flashed herself at the judge because she thought it would make the judge like her more. That didn't go over well. And have I missed something? Is this a repeat? We are going over this. We're just going over about 20 minutes of the end of the hearing because it was the end of the day and the audio sucked, basically. This is fresh audio from Court TV. Everything is great with this. So we wanted to give it all a good listen to where we can hear everything. And Ella Cole, new member. Thank you so much, Ella Cole, for being the newest member of the Clean and Sober crew. You rock. Thank you. Thank you so much, Ella Cole. All right. Back at it.
And his report indicates, quote, the weight of the credible information again points to the conclusion that Mr. Business is competent to proceed. And I offer that opinion to a reasonable degree of professional certainty to the courts for the court's adjudication, close quote.
Could be.
In analyzing not only their testimony, but the reports, I parsed through the reports, and frankly, it's actually difficult to parse out and unwrap Dr. Lighton's report regarding which piece relates to the NGI and which piece relates to the competency. Some things I want to just address regarding Dr. Seipel's report that I find meaningful, that I find insightful to me. I'm going to read a couple of those things. On page 14 of a report, he addresses his interaction with Ms. Schabusines, and I think it's very relevant. He says, quote, "Her commentary occasionally waxed somewhat provocative, for example, sexual or otherwise graphic. However, such comments were not directed at me in any form of threatening or solicitous manner. Rather, she simply seemed to be fishing for a reaction.
Mm-hmm.
Thus, I either ignored such comments or matter-of-factly acknowledged them before continuing with my line of questioning.
Thank you for showing
Through
me your
such an
boobs.
approach,
Please
I
continue.
was easily able to sustain Ms. Schabusines in rational, reciprocal, forward-moving discussion.
Yeah,
Her
see, that's what
replies
happens when
were
you
almost
act
always
crazy
relevant,
and your
albeit not always
psychologist is evaluating, goes,
and
nice,
she was
seen that
easily
one, been there,
redirected
done
and
that,
responsive
continue.
to prompting when needed. Moreover, in the few moments where she was evidently confused by questions, she easily benefited from simple accommodations such as repetition and rephrasing. Her expressed thoughts were consistently organized. I detected no credible delusional beliefs.
Yes,
finding,
Misty, this is the cleaned up
claims
version from
such
Law
as
and
that
Crime.
she believed Dr. Lighton to have stuck her tongue out had her to be entirely lacking in credence. I found that relevant. It was a direct reflection of what the doctor experienced when he was interacting with Ms. Schabusines. In another portion of his report, he notes, in any event, there was no evidence whatsoever of Ms. Schabusines being distracted by any form of hallucinatory phenomenon.
Yeah,
That's
there was
on
no
page 15.
trains involving Johnny Cash
Some
dying.
of the highlights that
Weird.
were also gleaned during the testimony. Page 16 of his report, he notes that Ms. Schabusines indicated that she can assist her attorney in her defense by giving him all the information possible. Thus, she offered that it is important to be forthcoming with defense counsel. So he's able to help me. He can't if I don't be honest. Indeed, she stated that she has been honest with Attorney Freilich about the circumstances of this case. The report goes on in another location to indicate, quote, "When considered in that light, there simply is no reasonable basis on which to conclude that Ms. Schabusines lacks capacity to behave appropriately and communicate rationally, given that she has now twice clearly displayed such capacities."
Mm-hmm.
It goes on to indicate, quote, "She has no difficulty grasping the roles of relevant courtroom personnel and the adversarial nature of the criminal proceedings." Again, I found all of those to be very insightful and credible. They seemed very credible. I've weighed the credibility of each of the experts regarding this topic of competency, and I find those observations to be credible from Dr. Seipel. I've observed Ms. Schabusines interacting with her attorney. Obviously, I can't hear what they're talking about, but as I sit up here, I can see everything that goes on in the courtroom. I can see them interacting, discussing. Ms. Schabusines indicates she thinks she can work with him. She understands what the courtroom procedures and players are. There's been occasions of inappropriate behavior, which Dr. Seipel indicated on testimony here, that he was fundamentally unable to rule out that they are volitional in nature. Satisfied based upon all the
She
evidence
meant
I've
to act
received,
that way.
greater weight of the credible evidence in this case, and my assessment of the credibility is included in that the greater weight of the credible evidence supports a finding that Ms. Schabusines is competent to proceed to trial, and I'm going to make that finding now. So that's the decision of the court.
So the decision of the court is that she is competent to stand trial, and that means we're doing it 24 hours from now.
Then regarding the competency hearing, that piece of this case is now concluded for today. The jury selection is scheduled to begin at 1 o'clock. I believe the jury was requested to report at 12:30, so they should be ready to go when all of us are sitting at council table at 1 o'clock up in branch 1.
All right. That is where we are as far as the court proceedings go. Now, after this, in the afternoon, they started with jury selection. And they did manage to seat a jury. So that's a good thing. The jury Well, let's bring up. There's an article. We'll read an article because why not? Let's see. Move out Doggo here for just a quick second. Here we are. This is the previous report. There we go. Previous report says that just hours before jury selection is set to begin, Green Bay murder and dismemberment, Brown County judge rules Taylor Schabusiness remains competent to stand trial. That's what we just watched. The judge made his ruling Friday based on 2 recent competency evaluations completed by 2 experts with opposing opinions. Judge Walsh said he reviewed everything in this case to date, including past evaluations, and also takes into consideration his own observations of Schabusiness in court. As he just said, as I sit up here, I can see everything that goes on in the courtroom. I can see them interacting, discussing. Schabusiness indicates she can work with him. She understands courtroom procedures and players. There have been occasions of inappropriate behavior that Dr. Siepel indicated on testimony here. He was fundamentally unable to rule out that they were volitional in nature. So then jury selection is set to begin at 1 p.m. Friday. Each side will get 7 strikes for voir dire. And I will say that I love the judge in the YNW Melly trial. He sounds like he grew up in Utah because he uses the Utah pronunciation of voir dire, which is voir dire. I love hearing him say voir dire. So that's bonus points there for the YNW Melly judge. Never get enough of hearing that voir dire. That brings me home. That was a random aside. Sorry about that. So they get 7 strikes during voir dire, and what that means is they just say, okay, for whatever the answer she gave, you're out. We just want to strike her. You get unilateral. You have strikes for cause, and then strikes for just occasionally you're given a certain number of just we just don't want this person on the trial on the jury. But one thing that they said, so they want 4 alternates. So there's going to be a total of 16 people in the jury box. They've got 4 alternates. Well, we'll talk about this in just a little bit here. Warning, details may be disturbing for some readers. Not for you guys. You guys rock. And then it just goes through the criminal complaint here that we read in detail. We have a super chat rolling in from the one and only Solon the Lich. Thank you so much for your super chat. Taylor Schabusiness insanity plea is as credible as the domestic violence victim status of the woman that got sued by J. Depp. F them both. Oh, I thought you were going to say the domestic violence victim status of Sarah Boone, who's also claiming that. Thank you so much for that super chat. Wow, that's like really tiny to read, isn't it? I don't even know why I put that up. I didn't realize it was that tiny for you guys to read. Well, how much can we embiggen this? Quite a bit, I guess. All right, there we go. So what eventually happened is this. The jury for the Taylor Schabusiness trial has been seated. 9 women and 7 men were selected Friday for the Green Bay murder and dismemberment case. Opening statements for the trial begin on Monday. So the jury has been sat. There are 9 women and 7 men. That's a pretty darn good break. And a pretty darn good split. And we don't know who the alternates will be, I guess, until the end of the trial when they'll decide who the 4 are that are going to be the alternates, assuming that they last throughout the trial, I guess. I seem to recall that's the way they did it. They told in Wisconsin, they tell the jurors at the end of the proceedings who the alternates will be. So there you go. Competent to stand trial. The jury has been set, and we are good to go for opening statements at that time. Still not sure exactly what the start time is, but normally Wisconsin starts around 9 a.m., which would be 10 a.m. Eastern, 11 p.m. my time. And I'm going to be doing my best to go gavel to gavel on this. My plan, and this is a plan because the trial would start at 11 p.m. my time and go till 6 or 7 a.m. my time. And then I work from 9 or 10 a.m. till 6 or so p.m. my time. So here's my plan, and I'm going to stick to this as much as I can. When I get home from work, I'm going to sleep as much as possible, get 4, maybe, hopefully 4.5 hours sleep before the trial. Then we'll cut it at the lunch break. I'll get an hour, 45 minutes sleep, and then we'll do an afternoon stream. And hopefully then when I finish that, I'll just go hit the gym and go to work and do it all over again. Take a nap at lunchtime again. That's the plan. If I get worn out, if I can't do it, then we'll go to what we've been doing with the YNW melee trial. I'll go as much as I can. I'll do as much as I can on it the day it happens. And then the next day we'll just play catch up as soon as possible. We'll start an hour early and try to catch up as quickly as possible. That's what we'll be doing. A Madman asks, will the Doggo Cam be free? We don't charge for Doggo Cam. Doggo Cam is just an achievement that gets unlocked. Yeah, that's how that. We don't. That would be crass to charge for Doggo Cam. We don't charge for the Doggo Cam. It's an achievement that's yeah. Right. So that was a relatively short stream. We got everything done that we needed to do today. I mean, from the judge. I don't mean this is a short stream. We're still going. We still have a lot of ground to cover here today. Sorry if I freaked anyone out. That kind of sounded weird. The court stream was a relatively short stream because we got everything out of it that we needed to get done. Now what we're doing is we're going to go through the motions. 2 motions I wanted to get to. These are, of course, motions that have already been denied by the judge, but I like the argument and I like the reasoning. So let's take care of that and see what we've got here. Tourette's Majestic. Hey, what's up, TM? Good to see you here, as always. Competent? Yes. Insane back then? I'm feeling yes. Well, see here, this is my non-psychologist, non-expert opinion on this. Nothing I say here is medical, psychological, or legal advice. This is just me spitballing what I feel. I think she's hurt her ability to argue that she had no idea that choking out and SAing her corpse of a boyfriend and chopping up into little pieces was wrong. I think it's going to be difficult for them to argue that because she tried to hide the body. She chopped him up and put him in various bags around the place. Her plan, as she told the police, she was so helpful in telling the police that her plan was to take the entire body back to her place, but she just got lazy. And that's when she said, "Oh, I can't believe I forgot the head." Yeah, so I think it's going to be it's going to be an uphill battle for her to argue that for the defense to argue that she didn't know what she was doing was wrong at that point in time because she tried to hide the body. And Stefan, Stephen Walk, thank you and welcome to the Clean and Sober crew, our newest of new members. Great. Stephen Walk is the new Vice Rax member, and we don't cut off my members here. That's all up to you. You know, you make yourself my member. You're my member as long as you want to. You're the only one that can cut off your membership. All right. Now with that little awkward spiel out of the way, thank you, people. Now the first motion that I want to look at is the motion to suppress evidence. And what evidence they wanted to suppress was evidence that was gathered under the search warrant for the Schabusines home. Right, there we go. Right. Let me remove Stephen Walk out of the way here and readjust my streets. All right, that's I guess let's see if we can go one click bigger. All right, let's see. Can we go one bigger? Oh, we can go two. Oh, no, that's too far. Yeah, that's too far. All right, there we go. This is as big as we can. That's what he said. Okay. Was she going to hide it or was she taking it to her place? She told the cops, not very good hiding. Well, like I said, she scattered bits and pieces around she put them in bags and hid them around the basement, and she hid his head and his head in a bucket. Not a great hiding place, but she still hid it in a bucket with a blanket over it. Did she try to take a bite? Well, that's the question everybody has. Thank you so much, Burnt Raw Toast. Thank you so much for that question. That's the question on everybody's mind, it seems. Did she take a bite? Did she have a nibble? And again, as I've been saying, I said earlier, when Meme Copium asked the same question, and as I've been saying since this trial started, well, not, I mean, since this incident started, if she did take a bite, if she did try a little sample, if you kind of cleaned off her fingers or whatever, that would be the least horrific thing she did. So that's not we'll have a nibble poll at some point, Meme. Don't worry, not today. We don't want to rule out all of our good poll questions today. We've still got a week of this. Right. Yeah, so, you know, she probably did. Oh my God. Let's do this thing. State of Wisconsin, plaintiff. Go ahead. Insert your Daryl Brooks jokes right here. Same state of Wisconsin, again, not showing up for a trial. Is the state of Wisconsin present? Nope, but their representatives, the prosecutors, certainly are. So, state of Wisconsin plaintiff versus Taylor Denise Schabusines defendant. Motion to suppress physical evidence seized from apartment premises at Eastman Avenue, apartment 1. That's where she was living at the time. Her roommate was some other dude who was probably thinking, holy crap, I'm a lucky son of a bee. Right. Motion to suppress evidence. Physical evidence seized from the apartment. 2. Brown County District Attorney, please take notice that the defendant, Taylor D. Schabusines, formally appears specially and by and through her attorney, Christopher T. Froelich, in this action and reserving his right to challenge the court's jurisdiction. Grounds, jurisdiction. Do we have, anyway, again, insert all of your Daryl Brooks jokes here. Moves the court for an order excluding evidence. This motion is brought pursuant to Wisconsin statute, yada, 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 on the grounds that the evidence was seized from the premises at the apartment in Green Bay, Wisconsin on February 23rd, 2022, or any other dates in which the defendant, Taylor D. Schabusines, had a reasonable expectation of privacy in the bedroom and entire apartment which she occupied, all in violation of the rights guaranteed to the defendant under the 4th, 5th, and 14th Amendments of the United States Constitution, Article 1, Section 1, blah, blah, blah. Lots and lots of case law to support the argument. Further, the defendant moves for exclusion from use as evidence, all derivative evidence. So they want to exclude all of the evidence they gathered and anything else related to that evidence. And here's a bunch of other cases they cite, which they think supported their claim. The defense makes the following statements in support of this motion. So here we go. This is the defense trying to exclude everything they got under the search warrant. Makes his argument in support of this motion to suppress evidence seized from the apartment. The defense asserts that the defendant did solely occupy a bedroom at the apartment. So she was the only occupant of the bedroom. The dude that was living in the apartment, he didn't occupy her bedroom. Bobby Baloney says Flux pushed Jeff off the stairs yesterday. Oh, Flux. Flux is here. Good Lord, my phone went wonky, but I'm here. So answer yourself. Yeah, for it's Minecraft. It's like literally in Minecraft. Yes, Flux has an alpha dog leading her pack of dogs named Jeff, and apparently she pushed it. She pushed me off a cliff a couple of weeks ago. Now she pushed me down the stairs. I'm getting the point here. All right. Here we go again. The defense asserts the defendant did solely occupy a bedroom at the apartment located at this address. It is asserted that Scott M. Toms slept on the couch. Okay, now she is 24 years old, and he's a year and a few months older than me. So this isn't there's an old man living in the apartment. Flux denies the allegation. Yeah, so there's a dude that's 30 years older than her sleeping on the couch. I didn't notice the date before. Right, so Scott M. Toms slept on the couch in the living room area of the apartment. The defense asserts that the defendant utilized and had free reign of the entire apartment and had a reasonable expectation of privacy in her bedroom and the entire apartment. This is important later. You'll see why this idea that they shouldn't have been able to execute a search warrant of her bedroom because they're saying that she had an expectation to privacy in the bedroom. But they're going to talk more about that a little bit later. The defendant had possession of the entire apartment as she slept there, ate meals, showered, changed, and stored clothes there, and otherwise used the apartment as her living space. Upon belief, Green Bay police detectives completed a search warrant at the apartment on February 23rd, 2022. The defense asserts that evidence was obtained from the apartment as a result of the search. So they searched. They found evidence. The defense asserts that the defendant, Taylor D. Schabusines, did have a reasonable expectation of privacy in the bedroom and entire area of the apartment at this address. The defense asserts that the defendant did not give consent to search the apartment. Okay, well, all right, the doggo has vanished. We'll reinstitute doggo cam if and when either one of them comes back in here. So, we're saying she didn't give consent to search the bedroom. Well, I thought that was the purpose of a search warrant, where they can do it without your consent. If they had a search warrant, why wouldn't they be allowed in her bedroom? Well, they're going to explain that. They're going to answer that obvious question. So, she has this expectation of privacy and that she did not give consent to search the apartment. Upon belief, the Green Bay Police Department Detective Craig Pacala, we'll call him Pacala because Pacala sounds weird. Pacala did apply for a search warrant at this address, which is part of a multi-unit apartment complex. Law enforcement officers did perform a search of the entire apartment, including the bedroom of the defendant that the defendant occupied and slept in. Here's where we get into the problems. Upon belief, the search warrant only names Scott M. Thomas in the search warrant. The defense asserts that law enforcement knew that the defendant resided at this apartment, and yet they failed to include Taylor D. Schabusines' name on the search warrant. That's an interesting issue. They knew she lived there, but they only got the search warrant, and the roommate, Mr. Toms, was the only person named in the search warrant. So they're starting to lay this groundwork of it was in Tom's name, and you searched her room that Tom's had no access to. Well, let's look further at this. The defense knew that, and yet they failed to include her name on the search warrant. The defense seeks to suppress all evidence found in the apartment because A, police failed to get a search warrant for the defendant's bedroom. B, police failed to name the defendant on the search warrant for the apartment. And C, police failed to get consent from the defendant to perform a search of the apartment. The search warrant of the apartment for the apartment is attached as Exhibit A. Well, let's go down and look at this. Scroll. Here is the search warrant. The state of Wisconsin to Craig Pacala, a law enforcement officer of the Green Bay Police Department, whereas Craig Pacala has this day complained in writing to the said court that upon certain property in the city of Green Bay, Brown County, yada, 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 persons named to include Scott M. Thomas, occupied by persons named to include Scott M. Thomas, date of birth, and is more particularly described as follows. Here it is. A multi-unit apartment complex. The apartment consists of 4 attached units, having 8 apartments in each unit. The complex is composed of brick, having white trimmed windows and black shutters. The goes on and on to give the address. The entrance door to apartment number 1 has the number 1 and a decorative letter S on the exterior. There are now or will be located. So when you get a search warrant, you have to specify what it is you are looking for, and you are only allowed to look for those things. Blood, concealed. There are now or will be located and concealed certain things, to wit, blood and or apparent blood evidence, DNA and other biological evidence, clothing, towels, sheets, bedding, and any other fabric material. Weapons, guns, knives, other instruments, ammunition, bullets, and shell casings, proof of residence. Identifying documents of other individuals living or temporarily staying at the apartment. Trazodone, trazodone medication and or its container, other illicit substances, drugs, and drug paraphernalia, and cell phones. Now they're searching for the trazodone because she told the police, "Yeah, we smoked some weed, and then we smoked some meth with my roomie, and after the roomie left, we shot each other up with trazodone, which is a massively powerful antidepressant medicine." So that's why they were looking for it, because she very, very helpfully told the police that it was there. Well, thank you very much. You're not helping your case. Please stop talking to the police. Right. So, and that these were used in the commission of or may constitute evidence of illegal activity, to wit, first-degree intentional homicide and Uniform Controlled Substances Act. They were going to get her on some drug charges. The facts tending to establish the grounds for issuing a search warrant are information given under oath by Detective Craig Pakala. I don't know. I don't know how to pronounce it. Sorry, Craig, if you're watching. Wherefore, said law enforcement officer Craig Pakala prays that the search warrant be issued to seize and search said property and its contents. Now, therefore, in the same, we did this. Commanded forthwith to search the property for said things, and if the same or any portion thereof are found, you are commanded to seize them and hold them secure in your custody and return this warrant within 48 hours before said court, to be dealt with according to the law. There we go. There's all the signatures that are needed, and here is the facts that they submitted as grounds for the search warrant. You can't just say, "Please let me get a search warrant for these things." You have to give this statement of facts to justify searching for what you are searching for. Hempland TX, thank you so much, Hempland. Thank you so much, ma'am. Hempland, Texas, with a $10 super chat. Here are some extra words for your busy polls this week: nibble, snack, munch, gnaw, feast, gobble, gorge, and devour. Wow, coming in strong with that one. Yes, trazodone is just a horribly nasty medicine that very few should be on. Yes, and she did, for those of you mentioned it in chat, she did call meth the bitch. We were smoking the bitch. People are asking whose name is on the rental. Well, let's get there. The facts tending to establish the grounds for issuing a search warrant are as follows. Your affiant is a law enforcement officer with the City of Green Bay Police Department. Your affiant has been employed as a law enforcement officer for the past 28 years. Since 2017, your affiant has been assigned to the investigative division. Your affiant has written several warrants and subpoenas during his law enforcement career. So in other words, I know what I'm doing. I've done this before, Judge. Your affiant has received training and experience in investigations regarding crimes. I know what I'm going to do once I get in there with this search warrant, including but not limited to human trafficking, internet crimes against children, homicide, battery, SA, and various property crimes. Your affiant makes this affidavit on personal knowledge, information, and belief. Your affiant, as a police detective for the Green Bay Police Department, also reviews and references multiple official police reports. We went through the information contained in those a couple of days ago, which have been prepared by law enforcement officers with the Green Bay Police Department. These reports contain factual information obtained from victims, witnesses, and other sources, which affiant asserts to establish the commission of the crimes of first-degree homicide, contrary to law. That these aforementioned reports are the type of reports similarly generated by police officers and detectives with the Green Bay Police Department. Your affiant has not only prepared similar reports through the course of his career, but also relied on said reports for other investigations and found them to be truthful and reliable. So this is what the other cops are telling me, and I know these cops to be honest, good people, and this is in line with what I know of them, to be honest. So on 2/23/22 at approximately 3:25 a.m., Green Bay police officers were dispatched to this address. The complainant informed a dispatcher with the Brown County Communications Center that his girlfriend found a severed human head in a bucket in the basement of their home. TLP believes the head is that of her son. So now we get to some of the information that it was the victim's mother's boyfriend that called the cops. He called the cops because his girlfriend, the victim's mother, found her son's head in a bucket at the bottom of the stairs. Your affiant reviewed the details of Officer P. Linsmeyer, an officer with the Green Bay Police Department. Officer Linsmeyer made contact with SCH, that's the boyfriend, who stated he had last seen SRT Monday, that's the victim, Monday night at the house with his girlfriend, Taylor Coronado. So for those of you that are wondering, we've mentioned it before, Schabusiness is surprisingly not her birth name. It's Coronado. She changed her last name legally to Schabusiness 2017 or 2018, somewhere around there. So she stated that he and TLP, so that he and his girlfriend did not see Coronado leave the house, but did hear a vehicle start and a door slam. Following the vehicle leaving, they went down into the basement and found what they believed to be a severed head. Your affiant reviewed the details of Officer M. O'Donnell, an officer with the Green Bay Police Department. He responded along with Sergeant K. Brester and Officer A. Wanish. They conducted a protective sweep of the basement area of the home. In doing so, Officer O'Donnell observed a 5-gallon bucket that contained what appeared to be a human head. The head, he stated, appeared to be that of a male with dark-colored hair. Officer O'Donnell also observed damp blood stains on the bed, blood drops on the floor near the bed, and blood stains on a mattress propped up against the wall. Brown County Dispatch, in searching for any recent police contacts with Taylor Coronado, found that her real name is Taylor D. Schabusiness. In addition, a recent prior address found to be related to Schabusiness was this apartment. Your affiant reviewed the details of Officer Whitman, an officer of the Green Bay Police Department. Officer Whitman responded to the Schabusiness residence, we'll call it, at the address. The officers located a van, Wisconsin license plate. The van was said to have been driven by Schabusiness, which was observed at 8:20 at the victim's place. In running the vehicle license plate, it was found to be registered to Scott M. Toms. So it was Tom's van that she was driving. On the vehicle registration, Tom's was listed at the address, at Schabusiness's address. According to Officer Whitman, as she and other officers approached the parked vehicle, Schabusiness was observed standing outside the apartment complex. Officer Whitman noted that Schabusiness's hands had a red substance on them. People think just the one head. Yeah, if you see like your son's head in a bucket, you're not probably going to go searching around to see what else is in the bucket. You're going to be horrified. Your affiant reviewed the details of Officer G. Russell, an officer with the Green Bay Police Department. Officer Russell responded to the Schabusiness house. According to Officer Russell, he approached the suspect van and looked inside. He then looked on the ground in front of the van. Your affiant viewed this area following Schabusiness and Tom's being detained. Poor old Tom's, he was detained as well. He's like, hey, dude, I don't know. I'm just doing meth. I don't know what you're talking about. I know this area to be a sidewalk located between the apartment complex and a parking lot. Officer Russell noted what appeared to be 2 specks of red liquid that resembled blood. So then Officer Russell stated that he placed Schabusiness under arrest for the outstanding warrant she had out for her. So we know she did have an outstanding warrant because that's the first thing she said. This also answered that question we had. She came out to meet the police and they said, do you know why we're here? And she said, probably has something to do with the warrant, with the arrest warrant. So yes, she had an outstanding warrant, probably for failing to return to jail. I don't know. While putting handcuffs on her, Officer Russell noticed what appeared to be smeared blood on her hands. In addition, Officer Russell stated he observed blood on the back of her sweatshirt. Your affiant reviewed the details of Lieutenant T. Bachman, an officer with the Green Bay Police Department. Bachman responded to the Schabusiness home. According to Lieutenant Bachman, as he and the other officers approached the suspect van, the doors unlocked and lights flashed, meaning someone had activated the system via a remote key fob. Lieutenant Bachman looked towards the north entrance to the house and observed Schabusiness exiting the building. According to officers on scene, Lieutenant Bachman was told Schabusiness was associated with apartment number 1. Lieutenant Bachman stated he ran inside the apartment complex by way of a common entrance located on the north side. Inside, Lieutenant Bachman observed the door to apartment 1 to be ajar. Insert, it's not a jar, it's a door, jokes here. Lieutenant Bachman stated shortly after the door to apartment number 1 opened and a male exited. The male, he stated, was identified as Tom's. Tom's was detained by officers and later transported to the Green Bay Police Department. Lieutenant Bachman stated he observed a small wet paper towel-like item and a cigarette in the hallway near the door to apartment 1. Your affiant, after Tom's was detained, viewed this item and noted that it was red-brown in color. Lieutenant Bachman ordered officers to maintain scene security at the scene. Green Bay, to include the entrance to apartment number 1 and parking area where the suspect van was located. At the Green Bay Police Department, Schabusiness was read her Miranda rights. So she was Mirandized by Detective D. Groff, a detective with the Green Bay Police Department. Schabusiness agreed to answer questions and understood her rights. So again, another thing. Yes, she said, yes, I understand I have the right to remain silent, so grab a notebook and listen to me talk. Yeah. According to Schabusiness, she and SRT, the victim, intended to, while at the victim's location, intended to engage in sexual relations involving a chain. Schabusiness stated that the victim died as a result of she tightening the chain around his neck. Following his death, Schabusiness stated she dismembered his body, placed his head in a 5-gallon bucket. According to Schabusiness, the van she was using was in fact the one located at her address. In that van, Schabusiness stated she transported 2 sections of SRT's body parts. Schabusiness stated she used a bread knife to dismember the victim. In her statement, Schabusiness said she and the victim smoked meth on the day prior. In addition, she stated that she crushed a trazodone pill, then injected both she and the victim with it. The drug use, according to Schabusiness, occurred at her apartment. According to Schabusiness, she resides at that apartment. Schabusiness stated she stays in the bedroom and Tom's sleeps on the couch. Your affiant knows, based on officers' details and statements made by Schabusiness, she made statements, that evidence items requested in the search warrant may support the charge of first-degree intentional homicide and a charge or charges under the Uniform Controlled Substances Act. They may be located at her house. The evidence would include, but is not limited to, clothing that Schabusiness was wearing, fabric materials that Schabusiness may have used, may have had contact. Ooh, let's take a little breather here and read a super chat, just to cleanse our palate a little bit. Rick Nikita dropping the $2 super chat. Thank you so much, brother. Shout out to my fellow drivers at YRC Freight. Hey, dudes at YRC Freight, shout out to you. Stay tuned for more Schabusiness. Hope you guys stay safe. Truckers, drive safely. People, put down your cell phones when you drive. It ain't worth it. So truckers, be careful. Drivers, don't make it more difficult than it needs to be for you or other drivers. This has been a public service announcement. So Schabusiness stated she resides at this location, returned there having left his previous address, and admitted to transporting the victim's dismembered body parts in the van belonging to Tom's. In removing body parts from the victim's location and placing them in the van, Schabusiness would have direct contact with the victim's body parts. As of 2/23/22, an autopsy of victim had not been conducted. Therefore, the cause of death is not known. For that reason, I have listed other weapons to be searched for in this affidavit, and some really, really bad. There's like a really bad printing line here where it seems there's an ink cartridge issue. Yeah. For those of you that are asking, like Jessica Roberts, about the YNW Melly trials because of the mistrial, I uploaded a video earlier today. You can go to my page and check that out. Or you can go to the YNW Melly playlist, and it should be the most recent video uploaded. And as long as we've pushed the pause button here for just a minute, let's get the other super chat out of the way here, so we don't get too far behind. Oh, 2 more have just rolled in. Congratulations on 57,000. Don't forget us OGs when you're famous. No, I'm only famous because of you, Julie O, and all you other OGs, all my Ride or Die Vice Squad. And if you're here in chat, you're automatically a Ride or Die Vice Squad member. I was just watching the Competency video yesterday, and you're more than what you're 1,000K more subs today. People are interested in this trial. The YNW mistrial and this trial are bringing people in, so stay tuned. I'm promoting this. I'm loving this, and we're going to be doing a great trial here. And Fondian, thank you for that service announcement. Fondian, another one of our truckers. Take care, brothers, out there on the road. I'm the son of a truck driver, so I hear you. All righty then. In addition, In addition to all of the horror we've heard so far, your affiant knows, based on prior investigations, that cell phones commonly contain data showing GPS coordinates and locations. Your affiant has investigated several cases in which suspects search topics related to crimes they're involved in at times. Don't do that, people. You don't make it easier for your defense lawyer when you do things like that. Record information related to crimes by way of photography and or video. Ugh. Yeah, so he's like, she may have taken pictures or video of this. Ugh. In addition, your affiant, again, based on prior investigations, knows that a cell phone is a common use of communication, be it text or voice calls. Weird that a telephone would be a commonly used item for making telephone calls. Good on you for that one, Officer Friendly. Wherefore, said Detective Craig Bacala, a law enforcement, and I know I'm changing pronunciation of his name every time just because I hope I get it right once. A law enforcement officer prays that a warrant be issued to search such property for said items, and if found, to seize the same and take the property into custody according to law. And that's it. Now we have the return, because he was told you had to execute the search warrant within 48 hours and bring back the receipts. Bring back what you have found. So this is the return of a search warrant by a law enforcement officer. I hereby certify that by virtue of within warrant 1 issued for this apartment was and found and seized and now have in my custody, subject to the direction of the court, the following things. Here's what we have in the search warrant. Here's what they found. Now, the warrant was served at approximately 12:47 p.m. on 2/23. The scene was released at approximately 3:08 p.m. So they were there about 2 hours and a few minutes. Law math, don't have time to work it out. Search warrant return. Items recovered. 2.58 grams field test positive THC in clear plastic bag. Green plant-like material. Green plant-like material testing positive for THC in a clear plastic bag. Whatever could that be, detective? Do some detecting. Tell us what that might be. The green plant-like material that tests positive for THC in a clear plastic bag. 15.7 field test positive. 15.71 field test positive for THC in clear plastic bag. Green plant-like material. And again, yet another green plant-like material in sealed Lume container. 4.96 grams field test positive. Motorola cell phone in suspect's bedroom. So now we're into the suspect's bedroom, clearly. Motorola cell phone in suspect's bedroom. On bed, black in color. Motorola cell phone located in pink purse on floor in suspect's bedroom, blue in color. Shabiz has 2 cell phones in her bedroom. What could a fine, upstanding 24-year-old woman be doing with 2 cell phones? If one of them's the victim's, that explains a lot. If both of the cell phones belong to the 24-year-old woman, that raises questions, but also I think they might be easily answered. But yet, wait a minute. Samsung smartphone with blue and black case located on the living room end table. All right, that would be Tom's, I would assume. And possible iPhone. What do you mean possible iPhone? In teal case with Apple symbol on back, found in living room. 2 people live at that place, but yet they have 4 cell phones. And lots of drugs. Why could you possibly need twice as many phones as there are people living there? Makes you wonder, doesn't it? Makes you ask questions. 3 syringes which appear are somewhat stuck together with sticky substance and or melted, located in suspect's bedroom dresser. 1 bullet located on living room floor, make model not obtained. Miscellaneous drug paraphernalia. And also some suspected THC trace amounts located in wooden cigar bod, I assume this box, on living room end table. Paperwork identifying the suspect as Tom living at the residence located in suspect's bedroom. Okay, so there's paperwork identifying the suspect that lives at and Tom's as living at the residence located in the. Why was the paperwork in her bedroom? This is what they're pointing to, and this is what's going to come up later. Swab of red substance on hallway wall north of suspect's bedroom door. Swab of red substance on light switch frame on suspect's bedroom door, on bedroom north of interior. And that's it. Interior of something, door. I guess that's door is door. So that's everything that had anything to do with a search warrant. That's what they found. And let's scroll back up to this statement here. As we can see what the arguments they made in relation to the search warrants. All right. Let's see here. We do. All right. We're all caught up on supers. And everything that I had start. Great. We love all you guys. Thank you for sticking this out here. Paragraph 5. The Green Bay police did apparently obtain consent to search the apartment from Scott M. Toms. Okay, Toms gave them. Toms, who also lives there, gave them permission to search the apartment. However, the law enforcement officers did not obtain any consent from the defendant to search the premises of her bedroom, and she also lived there and had a reasonable expectation of privacy in the bedroom and apartment. The defense argues that Scott M. Toms had no authority to authorize any consent search of the defendant's things, personal effects, separate bedroom, or the apartment. Defense argues that officers were required to get consent of both tenants and occupants of the apartment prior to any search. The defense argues that there was an illegal search and seizure of defendant's bedroom and apartment in violation of the Fourth Amendment of the U.S. Constitution. The defense does attach the consent to search form, apparently signed by Scott M. Toms, for the apartment. The consent to search form. I don't think, did we skip past that? Did we skip past that somehow? Okay, there's the return of the search warrant. I thought I had it. I thought I saw that somewhere. Endorsement by law enforcement officers. Right. There's the search warrant. There it is. It was before the search warrant. Lawyers put things in the proper order. Green Bay Police Department consent to search. Scott M. Toms voluntarily gives says officers or any assisting officers permission to search my premises, person, vehicle, property, as described. So permission to search the property. And so he gave permission to search the property. And it's interesting that he says my property. We're still not sure on whose house it's registered in. But what they're arguing is, yes, I mean, anybody at home can give consent to search that home. But then we get into this, okay, it's and maybe I see MLS Law here has been in chat for the while. You know, maybe while I'm talking about this, he can type in some more information for your benefit on execution of search warrants. Generally speaking, neither one of us being a Wisconsin lawyer, but you know, you can give consent to search if you're in there, and if you have a legal right to be in there, you can give consent to search the premises. And the defense is arguing that doesn't extend to a place where this guy doesn't go. And he doesn't go in her bedroom. So they're arguing that she should have a reasonable expectation of privacy from someone else consenting to search her bedroom. So, scroll back down to paragraph 5. He gave consent to search. And however, the law enforcement officers did not obtain any consent from the defendant to search the premises. Did not obtain any consent from the defendant to search the premises or her bedroom, as she also lived there and had a reasonable expectation of privacy in the bedroom and apartment. The defense argues that Scott Toms had no authority to authorize any consent search of the defendant's things, personal effects, separate bedroom, or the apartment. Defense argues that officers were required to get consent of both tenants and occupants of the apartment prior to the search. Okay, we now let's catch up again. Just wanted to rehash that. And thanks MLS for giving that little brief thing I saw over there. The defense does not attach. Sorry, again, this is how we got sidetracked. It does attach the consent form. The defense argues that the defendant did not consent to any search of the apartment or her bedroom, even if the state contends that the defendant did consent. So this is their thing. She may have consented. But they're saying she didn't consent. But again, they have no idea what she really did. She may have very well says, yes, go ahead and search everything. But they're arguing that the state, even if the state contends that the defendant did consent to a search of her bedroom and the apartment, then the defense argues, this is an alternative argument here, then the defense argues that this defendant was highly intoxicated on trazodone and meth and was suffering from severe mental health issues such that she could not consent to any search by a law enforcement officer. The consent to search form was signed and attached. So yeah, that's their argument on this motion, is that she didn't authorize it. But even if she did authorize it, she was so drugged out of her mind that she really couldn't authorize it. The defense does attach a copy of the search warrant and the other receipts. The defense asks the court to consider the GBPD, the Green Bay Police Department search warrant return, which states that the police found paperwork identifying the suspect and Tom's as living at the residence located in the suspect's bedroom. The defense seeks to have a formal motion hearing on whether law enforcement officers from Green Bay Police Department violated the defendant's constitutional rights under the Fourth Amendment of the United States Constitution for all the reasons set forth herein. So that's the argument they made. That's the argument that they made for the search warrant issue. So they want everything that they gathered from this thrown out, and anything relating to that to also be thrown out. And they wanted a hearing on it. Well, they got their hearing the same day they got their hearing on the next motion that we're going to raise. This is the more interesting two. Oh, MLS law is driving. Don't do that. Don't even do voice to text while you're driving. Sorry about that. Didn't mean to put you at risk. Stop that. Disavow. Was she arrested at this apartment? Yes, she was arrested at this apartment. She came out, met the police officers, and started talking immediately. So, right, they made this other motion. This is the motion to dismiss the charges. And here is probably where we're going to go straight into the red zone. This is where it usually happens, talking about this particular issue. We're not, usually you can kind of get away with stuff. If you've been more than 2 hours into your stream, you can talk about a little more spiciness, but we're not even close. Hopefully we'll be wrapped up before the 2 hour mark. So yeah, here we go. We're still yellow. We're still on limited ads, but these sexual assault charges. The defense wants the sexual assault charges thrown. And if you were following along with the criminal complaint, the charging documents, the allegation is that after he was deceased, he played with his body parts for about 3 hours. Yes, performing oral on his corpse, using a dildo on his nether regions after death, and then of course the infamous lopping off of the junk. So they want those charges thrown out. They want them dismissed. They just want them chucked out. And that's the argument. Their arguments are interesting. And I mean, and by interesting, I don't mean that facetiously. I mean, they legitimately are interesting arguments. The rationale is interesting. So let's review this motion to have the sexual assault charges thrown out. Oh, they'll stick. Both of these motions were denied. We'll get to that. They were denied, so that's part of the reason why we're going to trial tomorrow. How did they find out about that? I assume she admitted to doing that. Oh yeah. Yeah. She told them exactly what she did. Yeah, she said, here's what we did. She is the very definition of self-snitching. No texting while driving. Okay. Daddy Vice's law. No, it's not even a joking law thing. It's just don't freaking do it. Yeah, it's not even something I joke about. So drinking and driving and texting while you drive are two things I am horrifically, I mean, just staunchly and amazingly, just totally against in any way, shape, or form. So don't do it. Right. Here is oh, wait a minute. Why did I bring up the criminal complaint? We don't want to bring up the criminal complaint. Let's see. We need to bring up, let me open this here. Go to my business folder. Motion to suppress. There we go. The motion to suppress. Did I not highlight that one? Nope, guess I didn't highlight that one. Right. Well, this isn't very long. And it contains the same search warrant stuff. Oh no, come on. Oh, do not tell me. No. Motion to dismiss. Woo, there we are. I thought maybe I had mislabeled it. Thankfully, I had not. Great. Right. We are here. Who? Take a big deep breath. This. Right. I was just trying to think of how we could make this less gruesome. There's really not that good of a way. So we'll just grin, bear it, and get through it as we have doggo sighting here. Hang on. We'll just have to do our best to get through this in the best way we possibly can. Which is just go straight at it. But while we're here, let's take it's not even really a mid-team. It's near the end of the stream grift. We've been doing this for an hour and a half. Hopefully we'll be done here in about the next 30 minutes because I've got to get some sleep so I can prepare for trial on the morrow. So currently we have 683 viewers and 516 likes. That's a really good ratio. And I deeply, deeply appreciate all of you hitting that like button. Please hit that like button. People are hitting the subscribe button in record numbers. I deeply appreciate that. I think we can get to 60,000 subscribers by the end of the week, by the end of this trial. We're less than 3,000 away, about 2,800 away. So this is really good. Thank you for everyone that's showing support for this. Please hit the like button. Please hit the subscribe button. Tell your friends, colleagues, relatives, whatever else you want to tell about this trial. Let's go through this trial together, gavel to gavel coverage right here on Legal Vices. We'll get through it, and we'll have a great panel of guests. MLS Law is one of the people. I was trying to remember all the people that I had mentioned earlier and was coming up short on my brain because I hadn't expected to talk about who we've invited on that have said they might be here. But again, to go through that, to have to scroll down here through my, All right. Twitter is still being weird when it's coming to my messages. All right, there we go. Now we have the expanded message list here. MLS Law Show. We have Nicholas Starov. We have Steve Gosney, Danny on Direct. Let's see. Megan Fox, the medium smart journalist, not the one with the thumbs. LawTube Sean, potentially criminal. MG Law, Law and Lumber. And Natalie Wisco. Can't forget Natalie Wisco. Natalie Wisco is a Wisconsin lawyer. Of course, she is Natalie Wisco from the other guy's trial. I know she keeps it's not she hates but yeah, she's done more in her life than his trial. But she is from that trial. Natalie Wisco has also said she would be here if and when she is able to do so. So that's kind of that's some of the guests. And of course, Ozzy Overlord, Hayden, those are some of the people that we've invited that are going to be on here as the opportunity arises and as their schedule permits. But Natalie Wisco is going to be the good one. She's on the ground. She's Wisconsin. She knows how it works. And she'll be a good one to answer all of your Wisconsin specific questions. Right. So with that, let's get to this new motion. Bring it on up. Share screen, window. Wow, can you hear Yoda hyperventilating back here? All right. Share screen. Boom. Right. All right. Add the doggos to the stream here. What you doing, Yoda? What you doing? Yoda sticking his big old mug in the camera. What's up? You're blocking the view of Strawberry. Where are you here? What's up, Yoda? What's up, Yoda? Yoda looking for some FaceTime. Anyway, sorry for that little doggo distraction. Let's see how much can we embiggen this. One more click. Yep, that's too big. Step it down one. Yep. All right. Here we go. State of Wisconsin plaintiff versus Taylor D. Schabusiness. Motion to dismiss charge in count 3. Third-degree sexual assault and motion to dismiss. Defective complaint. The complaint is defective. So why on earth would this complaint be defective? I know those of you that heard me talk about it know why, but yeah. Here we go. Please take notice that the defendant, appearing specially by her attorney, Christopher T. Froelich, and reserving her rights to challenge the court's jurisdiction grounds, moves the court to formally dismiss the charge in count 3, third-degree sexual assault, felony. The defense seeks to dismiss the charge in count 3 due to lack of evidence, as more specifically set forth herein. Right. The motion and you highlight important parts. You bold and underline important parts of your motion. Basically, the whole first page is bolded and underlined for those of you that are listening as you drive or as you're doing other things. The whole entire first page is bolded and underlined. This motion is brought pursuant to Wisconsin statute number on the grounds that the court lacks jurisdiction. Now, hear him out here. This is actually a very good argument. This motion is brought pursuant to Wisconsin statutes, this and this, on the grounds that the court lacks jurisdiction over the defendant. Why? Why would the court lack jurisdiction over the defendant? The defendant was in the jurisdiction. Because the criminal complaint by which the defendant is charged is defective. This charge of third-degree sexual assault is defective. So therefore, the court has no jurisdiction. Well, how is it defective? Specifically, the complaint fails to set forth essential facts from which it could be inferred that the defendant committed a crime and fails to state the essential facts constituting the offense charged as required by law, all in violation of rights guaranteed by the 4th, 5th, and 14th Amendments of the United States Constitution. It's defective. Why is it defective? It doesn't tell you the facts, because when you charge someone with a crime, you have elements of the crime. When you charge them, you have to argue the elements of the crime. They meet this, and this requirement, so therefore they're being charged. And they're saying they didn't do that. It fails to state the facts that constitute the offense. And it fails to set forth the facts that you can infer that this particular incident of sexual assault occurred. All right, well, let's see his arguments. The defense claims that the criminal complaint and information is defective because there are insufficient facts to support the charge in count 3, third-degree sexual assault felony. The defense asserts that the criminal complaint is defective as to count 3 based on the information attached hereto and arguments to be presented at a motion hearing. Here are their facts they're using to support the argument that the sexual assault did not occur, or that there was errors. To be specific, there are errors in charging it. They didn't point out the facts that form the charge of sexual assault. The defense asserts there is insufficient evidence to support the claim that ST was sexually assaulted. The victim was sexually assaulted under Wisconsin statutes. Insufficient evidence. The state alleges that a dildo was placed into the anus of the alleged victim, yet the state lab reports yield an inconclusive for DNA evidence. Okay, there's no DNA there. So see attached Exhibit A, which is the state lab of hygiene report. The report seems to indicate that the swab from the dildo indicates that the possible contribution of DNA from victim is inconclusive due to the complexity of the mixture. So he was a possible source of DNA, but the mixture of DNA on the swab was very complex. Let that sink in a little bit. The state alleges sexual intercourse, yet the alleged victim's appendage penis was apparently found separate from the decedent's body. Yes, she said there was intercourse, post-mortem intercourse, but he didn't have a penis. The decedent was not able to consent as specified. Yeah, the penis was apparently found separate from the decedent's body. The decedent was not able to consent as specified in statute. The state seems to rely on comments from the defendant, who was under the influence of trazodone and methamphetamine on February 23rd, 2022, when detectives were interrogating her about the alleged sexual assault. The defense argues that the defendant's alleged answers to questions are not reliable due to her being under the influence of drugs. So we've got a lot to go there. Their arguments are, even though it's possible he contributed to the DNA that was on the dildo, but there was a complex mixture of DNA on that dildo. Two, the state says there was sexual intercourse, but he didn't have a penis because it was over there in the bucket. And even though the defendant explained everything and told them what had happened, he was too high on drugs to be held accountable. Kurt on civil law, what a wonderful day for law. Exactly, what a wonderful day for Schabudiness. Ooh, so yes, the DNA, he was possible contributor to the DNA, but I just don't like this complexity of the mixture of DNA on the dildo. So the jury instructions. Now this is where we get into the really interesting part of the argument. I mean, aside from like the really horrific things we just read here in 1, 2, and 3, if you're standing up, sit down. If you're driving, listening to this, you just may want to pull over for a while. This is a bit much. The jury instructions under Wisconsin jury instructions 1218A state impertinent part as follows. Third-degree sexual assault, as defined by statute of the criminal code of Wisconsin. I'm criminal code in Wisconsin, and I got your statute right here. The criminal code of Wisconsin. Lawyers, you have underlings. Spell check and underlings. Make sure that you don't put criminal code of Wisconsin. All right, back to your regularly scheduled program. Third-degree sexual assault is defined in the criminal code of Wisconsin is committed by one who has sexual intercourse with, in bold, another person without consent. So to be third-degree sexual assault, it has to be non-consensual with another person. Keep that in your brain. Put that another person line right up here in your noggin, right up there in your dome where it needs to be, because this is going to come back here in just a second. So it has to be non-consensual sexual intercourse with another person. So before you may find the defendant guilty of this offense, says the jury instructions, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. 1, the defendant had sexual intercourse with the victim. 2, the victim did not consent to the sexual intercourse. Well, sexual intercourse is defined as sexual intercourse means any intrusion, however slight, of any part of a person's body or of any object into the genital or anal opening of another. Emission of semen is not required. Ugh. Did not consent. Did not consent means that the victim did not freely agree to have sexual intercourse with the defendant. In deciding whether the victim did not consent, you consider what he said and did, along with the other facts and circumstances. The element does not require that the victim offered physical resistance. Jack Matt. But he was on her bucket list. Jack Matt, go to the timeout room right now. Go to the bad boy room. No. No. Jack Matt, but he was on her go to the penalty box. Shame on you. This is what I get for looking at chat in the middle of this serious document. Holy crap. Go to the penalty box. All right. Did not consent. I'm not going to go through that again. The victim does not require that the element does not require that the victim offered physical resistance. So Wisconsin jury instructions 1200A, remember, it says up there, one has sexual intercourse with another person without consent. Well, these jury instructions describe sexual contact, also requires that the defendant acted with intent to 1, cause bodily harm to the victim, 2, to become sexually aroused or gratified, or 3, sexually degrade or humiliate the victim. You with me so far here? I know you don't want to be with me so far, but are you here with me so far? All right, and the jury instruction 1200B, sexual intercourse means any intrusion, however slight, by any part of a person's body of or any object into the genital or anal opening of another. The defense argues that there is no evidence that the defendant put anything into the genital opening, penis of the deceased. Okay, the defense argues, I don't think that was ever a thing. The defense argues that any claims that defendant placed an object, dildo, into the anal opening of the deceased is without merit, based on the state of Wisconsin Lab of Hygiene reports. So remember, they said there was a complex mixture of DNA on ye olde dildo. So there's no evidence they jammed anything into his penis, and the dildo in the anus had a complex mixture of DNA. So he could only be a suspected contributor. Now here we go. This is why I told you to keep in mind right here that the third degree SA, as defined by Wisconsin, is committed by one who has sexual intercourse with another person. It's in bold, another person without consent. This next argument down here in 6, the defense argues that victim was not a person at the time of the alleged incident, as the victim was deceased, and therefore the Wisconsin statute does not apply. The defense asserts that once the person is deceased, they are no longer a person as defined under the jury instructions and Wisconsin statute. Okay, it's Yoda, please do not breathe heavily while I'm reading that. Please, for the love of God, go somewhere else, you silly bulldog. Yep. Please keep your breathing down for a minute, dog. Right. Eric Foams, lol, so you're just meat. Yes, well, take the lol part out of it, and you're right. That is what they are arguing. It has to be sexual intercourse with another person without consent, and he's dead. And once a person is dead, they're no longer considered to be a person under the Wisconsin statutes and jury instructions. So therefore, they're arguing that they could not have charged him with this because, actually, they could not have charged her with this because the alleged victim was no longer a person. How is that for an argument? I mean, it's a horrifically frightening argument, but it's not without legal merit. This is why statutes have to be very carefully written. Silent TPS, desecrating a corpse is illegal too, right? Well, she's already charged with that. That's the second charge, mutilating a corpse. She's charged with first-degree intentional homicide, like first-degree murder. She's charged with mutilation of a corpse, which is what you're talking about, the desecration of a corpse, and 3, sexual assault of that corpse. Yeah. So that's the argument that's being made here. We don't know because there's a complex mixture of DNA on the dildo. And 2, he was dead. So therefore, he's not a person under the statute. He ceases to be a person when he ceases to be alive. Yeah. The defense asserts that once the person is deceased, then they are no longer a person as defined under the jury instructions and statute. The jury instruction, Wisconsin Jury Instruction 1218, refers to into the genital or anal opening of another. The defense argues that there is no evidence to support the claims that defendant engaged in this conduct based on the lab report. The defense argues that there is no evidence that the defendant intruded into the deceased's genital opening, penis or anal orifice, as defined under the jury instructions. The defense asserts that there was an appendage parentheses, penis, that was detached from a body found on February 23, 2022, when law enforcement came to the home at Stony Brook Lane. The defendant was not at the Stony Brook Lane home when the police arrived on February 23rd, and the defendant was actually at the Eastman Avenue apartment on the date in question. There were apparently other alleged body parts. What is an alleged body part? I mean, yeah. So there were other alleged body parts found in a Jimmy Choo bag. I'm sure Jimmy Choo is pleased with that. Alleged body parts in an Under Armour bag and in a crockpot box found in the Chrysler minivan. And stay tuned. I think we're going to do at least one crockpot cooking recipe for the day, because that's what you chat seem to want. We'll do a crockpot Taylor Schabusiness cooking dinner thing. All righty. Yeah. So more alleged things found in a crockpot box in the Chrysler minivan. The defendant apparently blacked out as she reported to police. The defense asserts and argues that it would be unlikely and almost impossible for any SA to occur with how the dismembered body was found by law enforcement. Well, see, you can do that and then dismember the body. You can, that's kind of an option. And this blacked out as she reported to police. She said she blacked out, but when she came to, he was still alive. And she just decided to continue strangling him just to see what would happen. She told that to the police. So, yep. The appendage, parentheses, penis, was not attached to the body when it was found, and the appendage was unable to function due to its condition. I'm sorry, I cannot help but chuckle out of sheer horror for that statement. That's one of the most horrific sentences you will ever hear in the English language. The appendage, parentheses, penis, was not attached to the body when it was found, and the appendage was unable to function due to its condition. Yeah, we don't want to hear that sentence. Even Yoda is disgusted by that sentence. Was unable to function due to its condition. The defense argues that there is no evidence to support a sexual assault other than the defendant's own statements when she was under the influence of meth and trazodone. So again, even though she told them what happened in really graphic detail, she was out of her damn head on meth and trazodone. Those statements are going to be the subject of a motion to suppress hearing. The defense argue that no SA can be proven due to the penis being disconnected from the body that was found. The defense argue that no SA can be proven due to the unit being disconnected from the body that was found. The state alleges that a dildo was placed into the anus of the alleged victim, yet the state lab report yields an uninformative for DNA evidence based on swabs from the dildo. The swab from dildo, item J1, shows the possible contribution of DNA from victim is inconclusive. Again, this phrase, due to the complexity of the mixture. Per lab report, which is attached to Exhibit A, the defense attaches Exhibit B, dildo, which the state claims was used on the decedent's anal area. The swabs from the object are apparently inconclusive and uninformative per the lab report. The defense asserts that there was no sexual intercourse occurring between the defendant and the decedent. The defense argues that the police reports claim that the defendant stated that they were getting to that, which the defense argues that it means nothing happened. The decedent apparently had a chain that he apparently put around his own neck. The defense argues that there is no evidence that any object touched the alleged victim's anal or genital area. Attached is a lab report from the State Lab of Hygiene, which details the DNA results. 13 and final paragraph. The jury argues that the facts of this case do not apply. I think they meant defense. The defense argues that the facts of this case do not apply to Wisconsin because the sex organ was detached from the body that was found. The body was apparently dismembered such that it is unclear what occurred, as body parts were apparently found in different locations. The defense argues that it is impossible for the state to even be able to show probable cause that an SA occurred due to the fact that the body was found allegedly dismembered into many parts. The defense seeks to have a formal hearing on the motion to dismiss count 3, third-degree SA, and the motion to dismiss defective complaint for all these reasons as it relates to count 3. Well, damn, what do y'all think of those arguments? I mean, it sounds like a horrific thing to argue, but I don't think it's a bad argument to make. The statutes and jury instructions say that it must be a person, but that you also lose your personhood at the time of death. So therefore, it couldn't have been SA because he was no longer a person when it occurred. That was the argument they made. Yeah, and here's all of the DNA stuff that was tested. There's the buccal swab standard reportedly recovered from TAYLOR SCHABUSINESS, right hand swabs from SCHABUSINESS, left hand swabs, oral swabs from Shadtherian, swab from a blade, swab from a red substance inside a box, from the bedroom light switch, from the sweatpants, for penile swabs reportedly recovered from Shadtherian, swab reported from dildo. Screening, we go down here, swab from the blade, swab from the dildo, item J. Lots of redactions, lots and lots of redactions. Blood was not detected on swabs from red substance in the bedroom light switch. Must have just been strawberry jam. Presumptive testing for saliva was positive on... See, this is what doesn't make any sense. Presumptive testing for saliva was positive on penile swab from Shadtherian. Well, I guess it doesn't say whose saliva was found there, but yeah. That corroborates what she said about orally utilizing. Yeah. Mm-hmm. Buccal swabs, oral swabs, single source male profile. Okay, that's not his junk. That's from his mouth. Assuming the DNA from Shadtherian is present. Yes, it was his own stuff there. From Taylor's Business's right hand, from her left hand, from the blade. Shadtherian is the source of the DNA on the blade. Inside this box, there was two. This is weird. We don't care about the box. Red substances from the light switch. At least 2 males. Persons of interest, TAYLOR SCHABUSINESS, Shadtherian. Reddish brown stain from the sweatpants, left leg of the sweatpants. Reddish brown stain on the left leg of the sweatpants. TAYLOR SCHABUSINESS, Shadtherian. That's the DNA that was found. Right leg, non-sperm fraction. We don't care about that. Swab from dildo, 3-person mixture. Is that sunk in yet? Swab from dildo, 3-person mixture. Wash your damn toys after use. Before you use them again, wash them off. God. Assuming a 3-person mixture, at least 1 male. Assuming a 3-person mixture, the following propositions were used to assess the mixture profile in STR mix. Persons of interest, there's a greater than 1 in 10 to the 15th power that TAYLOR SCHABUSINESS's DNA was on that dildo. Very strong support for inclusion. It's at least 1 quadrillion times more likely to observe this DNA profile if it's a mixture resulting from H1. So yeah, it's like a one in quadrillion chance. Like, you know, It's 1 quadrillion times more likely that it's hers than anybody else's. Shad Therian. This is not a small number. 1.02 times 10 to the first power. Uninformative. Statistic values in this range have been observed both for individuals known to be in a mixture and known to not be in a mixture. Therefore, no conclusion will be made regarding the presence of DNA from this POI in the mixture. No indication as to who that third person might be. Ugh. Yes, it was the swab from the dildo, mixture of at least 2 males. God dang it, man. Men. Don't. Your DNA should not be anywhere on a dildo. Just saying. Moving right along. Additional possible trace alleles were also detected. Additional possible trace alleles. There may have been more than 3 people. No conclusions will be made regarding the trace alleles. Mixture is suitable for exclusionary purposes only. The possible contribution of DNA from Shad Therian is inconclusive due to the complexity of the mixture. And here's the technical appendix. I like how they call it it's the technical appendix that tells you all these numbers and what they mean. So, even Yoda's had enough of that. One last thing to share here, if you can handle a little bit more. That's, I mean, as horrifying as these arguments by the defense are in this respect, they're not without possibility. So, they had to be made. And it does raise a very interesting question. When does personhood end from a legal point of view? Well, all right, let's take a little breather here for a minute. Dunno says for the $5 super chat, no texting while driving. Okay, daddy devices. I know, again, lol. We already did this. I just want to go over it again because I brought it up and may as well just read it once more. Shani with another 20 Aussie super chat. Ashtray fun for your cigars. Jeffrey. Yeah, there's going to be a whole bunch of coming along in this trial. And yeah, there will be cigars and pipes smoked during this trial because I'll need to decompress a bit, and also by the power of nicotine, ye shall stay awake all night long and work all day. Thank you so much for that, John. Appreciate it. Lincoln Kane Shani. Anyway, again, mods, please throw up the Lincoln Kane Shani YouTube channel address in there. I would love you to death if you would all do that. Great supporter of the show. Truly a great man. He's done some very, very kind-hearted things for some very, very young people in need. He's a good man. During 1804, $5 super chat. Y'all know what the mortician does to you when they embalm you, right? Watching an embalming is actually a very fascinating process. Lady Autumn Sky, thank you so much for doing that. Flash them up a couple more times here in the next few minutes if you'd be so kind. All right. The last thing we want to do is, how did all of this turn out? What happened? What happened? They wanted a motion hearing for both of these motions. They got their motion hearing. This all took place about a month ago. And here we go. Let's embiggen it.
Good evening. Thanks for joining us tonight. The Green Bay woman charged with murdering and dismembering a man will not get another competency evaluation.
The request, one of several motions ruled on today by a Brown County judge. And
we know how all of the competency things turned out because we just watched them over the past couple of days.
The case involving TAYLOR Schabusines. The judge actually ruled on more than a dozen motions, most of them made by the defense. Brittany Schmidt sat in court for all 7 hours of discussion. She joins us live outside the Brown County Courthouse to walk us through those major decisions. Brittany.
Kim, after several hours of listening to witness testimony, the judge did weigh in on several motions. Many of them focused on Schabusines' statements to police during the interviews after the alleged crime was committed in February of 2022.
So just kind of pausing this here for fair use purposes. We don't know how copyrighty Channel 2 here gets with their cast, but we're doing this all for the purpose of commentary and, believe it or not, entertainment purposes. So yes, commentary, education, etc., etc. So it was a 7-hour hearing. They said more than a dozen motions heard, 2 of which included the motions that we just read.
The defense argued that Schabusines' statements that she gave to police were involuntary because he says she was under the influence of meth and other illicit drugs. The defense argues the use of drugs impacted her ability to recall and accurately report events. He says she was not in a state of mind where she could knowingly give consent to DNA swabs and waive her Miranda rights. The prosecution argues there's no evidence to suggest she was under the influence of drugs at the time of the police interviews. During witness testimony today, all detectives on the stand said they did not believe she was under the influence of drugs when they were in contact with her.
So yeah, when they're doing these motion hearings, they're bringing all of the officers on, they're putting them on the stand, and they're all saying, yeah, she appeared to be fairly normal.
The judge himself reviewed all the videos of the taped interviews. Here's what he witnessed.
I look at her physical demeanor as she's answering the questions. Everybody that testified here described, here's what you generally see when you're seeing somebody on meth. And they describe these characteristics that you would see. And yet when I observe Ms. Schabusines in these interviews, she seemed very relaxed, answering questions very, very calmly. And her demeanor was one of engagement and talking with the officers.
Yep.
For those reasons, the judge denied the defense's motion to suppress her statements. He also made the decision to not dismiss the third-degree sexual assault charge against Schabusines. Today's hearing wrapped up with the judge going through.
So there we go. They denied the motion to suppress the evidence that was found from the executing the search warrant, and the judge denied the argument that the SA charges should be dismissed for the reasons that the defense argued, which I'm just never going to repeat again if I can help it at all. So that's all of that evidence is in. The third charge, the SA charge, is still on the menu, so to speak. And all of the evidence that was gained from the execution of the search warrant remains evidence in the trial. All right, let's say goodnight to Yoda. Good night, Yoda. It's time for a little me time with chat. Hey guys, how are we doing? We still seem to be yellow in our monetization. I'm pretty sure we're either going to go red, or I've already asked for a review. I just hope they review the first 20 minutes or so, and not the last 20 minutes or so. Otherwise, it's going to stay the way it is. Well, trial starts, like I said, less than 24 hours from now. Gavel to gavel coverage right here with me and other peeps. And what we've got going right now is 673 of you have managed to sit through that last motion. Thank you so much, with nearly a 100% like ratio. I know there's been a heavy turnover of people. We usually average people stick around for 40, 45 minutes, but I know there's diehard peoples of you that stick around from the beginning. But make sure that all of you people that have not hit that like button, please get down and hit the like button. Let's see how our poll ended today, shall we? Today's Legal Vices like and subscribe poll was stab the like button, slash the subscribe button, and vote on how you think this trial will go. 8% of you said it'll be as dull as a kitchen knife. And it tied for the second place, I guess, with 29% each. It'll be a cut above the rest. And awesome, let's take a stab at it. And 34% of you said we need at least one crockpot recipe, because as you know, a leg and a foot were found in a crockpot box, which just begs the did she take a bite Did she take a nibble? Did she when she was done? And crock pot. You just have to make something. If there's body parts found in a crock pot box, you got to make a crock pot dinner. So we'll do a crock pot something during the week. I'll say I've been toying around with the idea of chili or maybe like a chicken adobo thing. I don't know what I'm going to do yet. Probably I'm leaning right down the middle, but it'll probably go more towards the chicken adobo because I haven't made chicken adobo. So alrighty there. That's what we're looking at. That's what's coming up. And thank you to all 646 of you who are still here. We've got some important things to talk about now. Gifted memberships and other things. Because a lot of that was going on in the background here while I was reading through all of this. So let me scroll back up here and find us. Hempland, Texas, gifted 5 Legal Vices memberships. Shani, aka Lincoln Kane, the LC and Shani crew, 10 gifted memberships, 10 more gifted memberships, 10 more gifted memberships, 10 more gifted memberships, 10 more gifted memberships. That's a total of 10, 20, 30, 40, 50 gifted memberships from Lincoln Kane and Shani are the peeps. Absolutely amazing individuals. And if you watch the streams, you watch what he does on his channel, it's loose form format. I would describe it as F it Friday 24/7. But it can be much more entertaining. Lincoln Kane is a true gentleman. I said I won't stress it too much, but he did help out and do a fundraiser for a very, very young child in very, very terrible circumstances. In just a few short hours, an entire additional ramp to allow access for this kid to get his house was raised. He cannot be praised enough for that. A true gentleman who helps out numerous people. Lincoln Kane is a gentleman, and his partner Shani, she's a true Aussie Sheila. All right, that catches us up with the super chats, the monthly memberships, the gifted memberships, etc., etc. Now, here we go. Less than 24 hours from now, this starts. Don't miss it. We're going to keep you updated. We're going to do gavel to gavel coverage, and I'm expecting a huge turnout for this. So make sure you tell everybody, promote it as much as you can, spread the word. Let's get as many people here as possible, and we'll get through this. It's scheduled for 5 days, Monday through Friday, which means there's not going to be a lot of evidence going on because jury instructions and opening arguments are going to take most of one day, and then you add another day for jury deliberations. So you're looking at probably 3 days of real meaningful testimony. Tuesday, Wednesday, Thursday-ish. So stick with it. We'll be there. Thank you to everybody that joined. I've now got to get as much sleep as possible because it is game day tomorrow. It is D-Day. It's actually D-Day now here because it's 12/16. So about 22 hours from now, 22, 23 hours from now, the trial will start. I will be here. We will get it started. We will rock. Thank you to everybody who has been here. We have the greatest chat on the internet right here. The Vice Squad, you are the best. Mods, I've got the best mods. You guys rock. Thank you for being so super cool and super moddy. Thank you, chat. Thank you for all the generosity. Thank you with the super extra special big thanks to Shani and LC for being the Vice Racks of the day with the highest super chat, a whopping 200 Australian dollars, which, as you can see here at the scroll, comes out currently to $134.56 US. Thank you. Thank you for the generosity. Thank you for the support. We'll see you all tomorrow. More than 1 year in the making. The Taylor Schabusiness trial starts tomorrow, folks. Don't miss it. I am Legal Vices, saying whatever you do, whoever you do it with, however many times you do it, however good it feels, whatever you're doing in the first place, just make sure you enjoy your legal vices. Until tomorrow, Law Racks out.